this kind of goes back even further to knowing something before you get into the transaction. So stuff like your disclosures and stuff, right?
Hmm.
So let's just kind of go to this point, like you said, that you get down to the finish line, and now you got this problem happening, right? And in the hypothetical situation that you got these, and I know that there's probably going to be thousands of answers, but if you got one that just sticks out of something that may have happened or whatever, and how you guys kind of dealt with it in the whole, let me know. But like you get past all these deadlines, and next thing you know, they got a dispute now, in this scenario. How do you guys handle the dispute, like over the escrow type of scenario? Like, do you leave that back on the broker to go through the process on their end? Do you guys have your own process? What is it that you guys do?
So the contract actually has an escrow dispute procedure, which we have to follow. Our role is really to educate people and trying to explain that escrow dispute process to them, which basically the contract states that when there is competing claims for the escrow deposit, the parties have to, this is what the FAR contract you mentioned, the parties have a 10-day cooling off period because the contract wants people to let cooler heads prevail, and usually it's worked out during that period.
Mm,
Because when there's an escrow dispute, tempers flare, a lot of high emotions. And so I think our role is really, we truly try to be conciliatory, and help explain the escrow dispute clause. 'Cause a lot of people think like, well, I'm gonna get that money tomorrow. It's no, you have to go through the process. So after the 10-day cooling off period, the parties are then forced to, or not forced, but they must go to mediation.
right.
And then if mediation fails, then it can actually go to litigation in the court process. So, I think when we see escrow disputes, we really try to convey to each party, what's at stake here, and trying to, explain their rights, and their obligations.
Hmm.
Um, like I said, most of the time it gets worked out in a 10-day cooling off period. But I think listening to people is what's really important, because a lot of times when, those tempers do flare, really hearing what they want, what they need, and trying to help them in any way they can.
Yeah, and that's important to know, because a lot of people think that they're going to go straight off, and because I mean, not for nothing, but you know, uh, it's one of those things where I've been in several transactions where, the buyer and sellers had, basically a temper flare type of scenario. And, oh, this is done. Listen, I went through a most recent transaction where it was, I just wanted to hurry up and be done with it, like it
Oh,
was,
yeah, we have those transactions too.
yeah. And I was wanting to be done with it. And, sometimes it's like, guys, you're gonna have to figure this out. And, luckily after that cool, some cool time, it did, kind of work itself to the top of
Yeah.
figuring it out. But yeah, they just sometimes they get carried away, and you're right. If there's on these on the FAR bar, the Florida bar contracts, it's like they already got something, a provision for that. But I just like to hear that, because sometimes I've been in situations where I think some of the things, some of the contract doesn't. Luckily, it all works out,
Hmm.
between the buyer and the seller. But I've actually seen it to where it doesn't. Not everybody's following the same guidelines or whatever. Because I tell people all the time, I said, if you want to go through every little step, and I mean, let's just say you're right. Let's hypothetically say you're right. But you know what? It's the most expensive thing in the world to be right.
Hmm.
And I go through that, and I say that because I appreciate, because I've had agents, they get upset about things, and because it's not going the right way, and I'm agreeing with what they're saying. It's not that I'm against at all what they're saying, but sometimes you got to pay to be right, and you got to weigh those things out. And that's kind of my advice. And I say, look, you got your rights, you got whatever you're gonna do, seek attorney. That's my number one thing to them. I said, look, I'm not the guy to talk to about it. If you really feel that way, seek an attorney.
Yes.
And that's the way we do it. So at the end of the day, I'm trying to educate them based on the knowledge I have. But I say everything. I'm not an attorney. You seek an attorney. That's the number one thing. So I tell people that because I don't want them to start a whole process, because a lot of people, I've had it to where people think they, even on the simple things, not even the bigger things, but simple things, they think they're doing the right thing, and it's
Yeah.
not even the right thing. It's the
Right.
big thing.
That's sound advice to give to your clients because, as Michael said, when we get clients, as Michael said, we're listening to them because they all have different varying needs and wants and requests, and it's important to finely attune your listening skills to the specific client so that you can adequately represent them, so that you can adequately do whatever it is that they want and do it efficiently and effectively.
And I think when you listen to them and you actually hear, sometimes you come up with solutions that maybe they're not thinking of. You say, okay, well, it sounds like this is what you're really going for and what you need here. So, offer them another proposed, solution to that. I think that's one of the most important things is listening to people.
And options, when you're listening, is to be experienced enough to give options, or if you're not experienced enough, and this is what I tell the newer agents that come on too. It's like, if you're not experienced enough, come to me, let me know what the situation is, and then we can let's see from here. But as soon as I hear dispute or this, I was like, just the only offer advice you got is seek attorney,
Mhm.
because that's it, that's all you got right now. But I try to go through that process to make them understand the difference in the where we begin, where everybody else picks up, and that's the key component, I think. And so this kind of leads me into another thing, because it talks, this kind of covered a little bit about the escrow and disputes and so forth. One of the things I see a lot going on in this in Florida right now, and and don't get me wrong, I'm not gonna what I consider to be bashing on these type of industry within itself is wholesalers. I get a lot of wholesalers. Those of you who don't know, it's like they put a contract, a sales contract, and they have it to where they can assign it. They can sell the contract.
Mhm.
And that's the kind of thing that I've dealt with. But I've also seen it to where, how, like, do you have to have like the escrow deposit down? Do you have to put money down on a real estate transaction for the escrow? I mean, like, in other words, if I get into a contract, can I just put zero under the thing, and or does it matter? Is the contract still valid at that point?
That's a great question. In fact, this is all between the agreement of buyer and seller.
Correct.
So the answer to your question is yes, you can have zero listed on that contract. It is just a matter of whether the seller is going to accept that certain offer when they see no money down into escrow.
Right.
Because that's really what the escrow deposit is about, showing to the seller that you are a serious buyer and that you're coming in good faith and that your money is earnest. That's essentially what it is. So the answer is yes, you can have zero. And I'm sure there are sellers out there that will accept a contract with a zero escrow deposit, especially the ones who are very eager to sell. But the chances of that happening are probably slim
Mhm.
because sellers do want the buyer to put something down to show that they are serious about purchasing one of the most largest investments people have in their lives.
Yeah, because that's the other thing is like, it's in what I see on a regular, right? As I deal with some, they actually, I've seen it to where they have zero. And I'm like, well, you guys, I don't know why, because I feel like you said, you're when you come in with something, it's earnest, showing good faith. You know what I mean?
Yeah.
I mean, that's, you got to have some kind of what I call the dog in the fight, so to speak,
Yeah,
right?
exactly.
And that's the way I look at it, is having the dog in the fight. And then when you're going through these transactions, I just think about, I go back to all the paperwork with everything that we're discussing and everything, and timelines and so forth. Have you had to deal with even like a transaction that has pretty much like the original contract, the middle contract, which is the assignment contract, and having to try to keep all those timelines together as well? Has that been something that's been frequent with you, or not much?
I don't see that very often, maybe a handful of times, but that's not very frequent in my world. I don't know, like you said, I don't know a lot of sellers who would accept, an offer that didn't have any money on the table, but I'm sure it's out there and I'm sure it does happen. Whatever comes into play comes across my desk, whatever timeline fits is the way that we go with the transaction. So if it's assigned, then I guess that the earnest money, if there is any, would transfer then over to whoever's holding escrow in that case. But that's not something that comes across my desk.
Yeah, no, and I think about that because I can only imagine if because even when I get them come across my desk, so to speak, is that I look at it and I say, well, there's no money there, you know.
Well, an example of where there will be zero is if you're selling between family members, you still have to have an arm's length transaction. But oftentimes a family member is not going to require. I mean, sometimes depending on your family, but
Right.
oftentimes if it's going, between family members, you'll see zero. Or I've even seen very very close for like their neighbors, their best friends next door. They'll put zero because you already have that trust factor. It's really when you don't know who's on the other side of that contract that they're going to require, escrow to have.